is Michael Hillens, Senior Counsel of Johannesburg. I appear, together with Mr. David Jabir, SC, instructed by Rudy Krauser of BDK Attorneys on behalf of Mr. Ajay Gupta. But I do so in relation to the Rule 3.3 notices served on the 6th of August in respect of the evidence of Ms. Faiki Mentor and Mr. Temba Maseko. They were left at the gate of the Saxonwold residence of Mr. Ajay Gupta. I do not appear in respect of the evidence or implications of the evidence of Mr. Mcebisi Jonas. I also represent with the same team Mr. Ajay Gupta in respect of any other allegations that may be made, and we've heard a wide-ranging and very able introduction by Mr. Pretorius on the length and breadth of that which is going to be dealt with in this commission. It would appear to us that we may be due a number of other 3.3 notices, but at the moment we just have those two. And as indicated in chambers, we would invite the evidence leaders to engage with us and to give us such notices as soon as possible. To sketch the background or the introduction to our appearance here is that naturally, as with the rest of the nation, we've known that the Commission would start, but when and how and what the mechanics would be were not known to us until at least the 3.3 notices were served, the Rule 3.3 notices were served, and in part also the able address of Mr. Pretorius. So now the planning from our side can ably begin, but the rules, as you are aware and the public should know, require us firstly to be given reasonable notice, and we know, sir, that the Commission had to start somewhere, somehow, and you've done a lot of work in being ready to prepare. So we make no complaint of what is technically short notice. We simply propose to put in place, by, if you'll give us leave to negotiate with the evidence leaders, a reasonable time frame in which to deal with the evidence. At the moment I'm speaking in relation to the evidence of Faiki Mentor and Mr. Maseko, but I speak also broadly to my learned friends on my right and left in relation to such future pieces of evidence that may call for cross-examination or evidence from our clients. So the notices state that the witnesses will give evidence at the hearing commencing on the 20 August, but we know that this is the commencement and not necessarily the date on which all these witnesses will give evidence. It appears to us that whatever the plans are of the Commission need not be interfered with by our temporary and justified lack of readiness, because the witnesses, in our respectful view, can still give evidence in terms of the planning of the Commission, because transcriptions will be available and no doubt even video facilities might still be available. So we would not interfere with the program of the Commission in relation to when the evidence is led, but we would ask that we make practical arrangements, not aimed at delay, merely to get ready in terms of the rules, to present cross-examination and to present such affidavits or evidence as we are required by the rules to file in order for you to exercise your decision-making powers in relation to the range of cross-examination, the nature of evidence, and the differences between what the Commission is leading and what we might want to put forward. But for that we do need a little time. We've discussed that broadly already in chambers, and I'm sure my learned friends and I and my team will reach accommodation with each other. Just a slight correction without starting the war. We have not been given due notice, as Mr. Maleka said, under the rule. It's actually quite short notice, but we make no complaint about that. And in a nutshell, we would ask for time to make appropriate arrangements for us to represent our client, at this stage Mr. Ajay Gupta, in relation to the two raised issues. But at the same time, we indicate publicly and to my learned friends, if there are other issues, please give us time's notice so that we do not delay the proceedings of this inquiry. Our suggestion, just to think about, is given the demands on our time in relation to our own practices and prioritising being ready, we believe we would be ready to cross-examine by the first week of September at the latest, but the actual detail we'll deal with the evidence leaders, subject to your decision, sir.